It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning, and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney J. Bryan Nugen, founder of Nugen Law, and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as protecting money from nursing home stays, securing benefits from programs like Medicaid and the VA, geriatric care coordination, estate and trust administration, guardianships, and planning for those with special needs. Nugen Law sees clients in many stages of life, but commonly we have folks reaching out when they or a loved one are showing signs of needing help. Those signs may include a chronic ailment, a progressive decline, before, during, or after a hospitalization, an instance of incapacity, caregiver burnout, stress on family members due to some or all of those instances I mentioned. So as a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. So if you hear something in today's broadcast which resonates with you, an area in which we're able to help, please call Nugen Law at 260-925-3738. Speak with one of our intake specialists and schedule a meeting for either our Fort Wayne or our Auburn locations. You are also encouraged to see us online at www.nugenlaw.com. To our listeners, Nugen Law will be presenting a free seminar on August 15th between 1 p.m. and 5 p.m. in Fort Wayne, with a deeper dive into how you can be sure to preserve your dignity, protect your money, with topics like asset preservation, securing benefits to provide payment for your care as you age, care management as you age, estate planning, elder law. Please give us a call at 260-925-3738 to reserve your spot. If there is a topic you'd like for me to address here on our radio show, please send an email to us at help, H-E-L-P, at nugenlaw.com. We'd be happy to hear from you on topics relevant to you and your family. Let's look at some numbers. So 10,000 people a day turn age 65 in the United States. Seniors are the fastest growing population in the U.S. 16.8% of the U.S. population is age 65 or greater. That means 55.8 million people are in this age bracket. This is increasing to 88 million by the year 2050. So every week on our radio show, we discuss many topics related to our aging population. It got me thinking that some of the terms we use are familiar to me and to the guests we have on, but that may not be as familiar to you. So today, I'll discuss several instruments and terms that you'll hear us use regularly and with which you, our listener, may want to become familiar. Let's start by discussing estate planning attorneys and elder law attorneys, how they're similar and how they're different. So an estate planning attorney, their job is to plan for transfer of your assets at the time of your passing. They're going to be planning for either going through probate or avoiding probate where it makes sense. They may also be preparing ancillary documents, powers of attorney, healthcare rep designations, etc. An elder law attorney does all of that, plus they're knowledgeable about how to protect assets that may need to be spent as you age. So they're educated and regularly involved in protecting those assets, preserving your wealth, and then securing benefits to provide for your care as you age. So estate planning attorneys, really their scope is limited to what's happening during your lifetime, and then in the sense of preparing ancillary documents, living wills, powers of attorney, healthcare rep designations, and then planning for probate or not to go through probate. Whereas elder law attorneys do all of that and so much more. It's a much more robust field when caring for elder law clients, senior clients rather. So what are some of the documents that may be prepared at Nugen Law if you're a Nugen Law client? Let's talk first about a durable power of attorney. So a durable power of attorney appoints someone that is able to make decisions on your behalf for things that you would do in writing. So that could be signing a check, making an investment decision, talking to a financial advisor, buying and selling real estate. So this person could do for you whatever you could do in writing. There are typically two types of powers of attorney. One is called springing, and one is in effect immediately. So springing is only in effect if a certain event happens, typically become incompetent, whereas generally a power of attorney would be in effect immediately. I am a fan of POAs that come into effect immediately and aren't springing. I don't want the delay in having to declare someone to be incompetent. I don't want there to be a challenge to that. And frankly, if you as a client have a concern that the person that you're appointing, if they would be able to access your assets immediately and you feel that they might do something inappropriate, right, might take money from you or make poor investment decisions, then they probably aren't the person for you to appoint to serve. And so I'm an advocate for powers of attorney that are in effect immediately and are not springing in nature. What's the next document you should be familiar with? A healthcare representative designation. So a healthcare representative designation, unlike the power of attorney, is only in effect when you are incompetent. So this document allows someone to make decisions about your person, about your health care, if you're unable to make those decisions. I should say not only if you're unable, but when you're unable to make those decisions for yourself. So you're always in charge of your own destiny. The only time that this individual that you've appointed to be your healthcare representative is able to make those decisions is if, in fact, you are determined to be incompetent, incapacitated. So you have a car accident and you're in a coma, you have dementia, and you've been declared to be incompetent, then that power of attorney, that healthcare representative designation is in effect, and the physicians can speak with that individual that you've appointed. And I do like to see just one individual appointed in the instance of a healthcare representative designation, because when you appoint two people, you have two different opinions. And one thinks, everybody's on the same page. Well, we think they're on the same page until there's a pressure moment or some tough decisions need to be made. So I really like to see just one person serving in the role as a healthcare representative and not two. The next document you should be familiar with is something called a living will. So a living will on its own indicates if the effort to sustain your life is futile. So you're actively passing, there's nothing more that can be done. In that instance, do you want to be kept alive in a persistent vegetative state? Do you not want to be kept alive in a persistent vegetative state? In my career, I have to say, I think I've had one person indicate that they wanted to be maintained in a persistent vegetative state. Aside from that, most of my clients have always indicated, a great majority of my clients obviously have indicated that if the effort to sustain their life is futile, that they do not want to be kept alive in an artificial condition. No artificial hydration, no artificial nutrition, just let me pass. Those living wills now in Indiana are typically part of the healthcare representative designation, so it's all the same document. And then I'd like to see a separate HIPAA waiver. HIPAA stands for Health Insurance Portability and Accountability Act. I'd like to see a separate HIPAA waiver signed by Nugen Law clients, and I like it separate, even though there's language within that healthcare rep designation that permits access Oftentimes, hospitals and doctors' offices are used to seeing a separate HIPAA waiver, so I think it's smart to have one that's separate. You as a listener should be familiar with these. If you've ever gone to the doctor or the hospital, they have you sign, typically electronically, a HIPAA waiver for that event, that one time that you're there at the hospital, that one time that you're there at the doctor's office. But the HIPAA waiver that I recommend for my Nugen Law clients is in effect indefinitely. So it can be used for any number of appointments, any number of visits, etc. So if you would like to learn more about what I've been talking so far this morning in detail, I encourage you to attend our free seminar on August 15th between 1 and 5 p.m. here in Fort Wayne, taking a deeper dive into how you can be sure to preserve your dignity and protect your money, with topics like asset preservation, securing benefits to pay for your care as you age, geriatric care management, estate planning, and elder law. Please give us a call, 260-925-3738, to reserve your spot. As I've said before, we represent clients in Indiana, Ohio, Michigan, and Florida. If you hear something in today's broadcast which resonates with you, an area in which you may be able to help, which we rather may be able to help you, please call Nugen Law at 260-925-3738. Speak with one of our intake specialists and schedule a meeting for either our Fort Wayne or Auburn locations. You're also encouraged to see us online at www.nugenlaw, that's NUGENLAW.com. And if you'd like to text the word Nugen to the number 45364, so on your smartphone, if you text the number 45364, text to that number the word Nugen, you'll receive a text message with our contact information. So let's move on in our discussion to now talk about probate. So what's probate? You oftentimes hear people saying, oh, you should avoid probate, or I want to avoid probate. I want to reduce my expenses by avoiding probate. So what is probate? Well, probate in and of itself is where your will is taken after you pass, is taken to the courthouse. It's filed with the clerk's office, filed with the court, and we open an estate. So when we open an estate, we open estate administration. Then notices are sent out to creditors that may be owed money by the deceased. An advertisement is put in the newspaper. Notices are sent to all of those individuals that are may be receiving or may be interested in the estate, the funds in the estate, to receive something. And it allows third parties that believe they're owed money by the deceased to file a claim in the estate, and it's public. So, as I say, notices are sent out, newspaper advertisement happens, it's filed with the court. So, technically, if a nosy neighbor wants to see what your will said or who's getting what, they would be able to do that. And then throughout the course of the probate process, we are providing accountings and other information to those that are interested in the estate, and they are signing off saying, yes, I approve of this. Yes, I accept the money that I've been offered, and then we close the estate out. How long does that process take? It isn't difficult for a probate administration process to take a year, sometimes longer, sometimes shorter, but it isn't difficult for it to be a year in length. I'm sure you've also heard the phrase intestate succession. Maybe not. So if not, this is the first impression. Let me talk to you about intestate succession. So for those individuals that didn't prepare a last will and testament, for those individuals that didn't look ahead, and either because we had an unexpected death or they just didn't do it, didn't get around to doing it, then the state doesn't actually get your money, but the state has established a protocol as to who gets what. And people are always surprised to hear that if you have children, your kids are guaranteed to receive a part of your estate. It doesn't automatically all go to your spouse. That's especially true if we have a second marriage or third marriage, etc. So it's always best to have that last will and testament in place, and in order to determine where your funds are going to go. So let's get to that. Last will and testament, what is that? A last will and testament is a document that you're preparing, signing in front of witnesses, indicating who is it that receives your assets. From what assets are certain debts to be paid? Do I want my money to go out to my children all at once, or do I prefer them to have multiple bites at the apple so they get the funds at ages 21, 28, 35? I like the multiple bites at the apple approach. I like it because it allows the recipients, if they spent the first distribution very quickly, it allows them to think when they're getting the second distribution, boy, that first one went fast. Maybe this time I'll try and preserve it a little bit better. I will invest it a little bit more securely. And so I encourage folks to consider, when they're doing their last will and testaments, consider having money given out to their beneficiaries over time. So if you'd like to learn more about this type of work in detail, some of these instruments I'm talking about, I encourage you to attend our free seminar on August 15th between 1 p.m. and 5 p.m. here in Fort Wayne, taking a deeper dive into how you can be sure to preserve your dignity and protect your money with topics like asset preservation, securing benefits to pay for your care as you age, geriatric care management, estate planning, and elder law. Please give us a call at 260-925-3738 to reserve your spot. So, probate. If we want to avoid probate, the expense, the public nature of probate, what do? Well, oftentimes we'll use a trust. So a trust is not something to be afraid of. A trust is something that not just the uber wealthy have. These are very common and are used on a very regular basis. You can avoid the expense of probate. You can avoid the length of probate. You can keep your matters private. So your nosy neighbors can't look at what you did with your estate planning. No publication in the newspaper. None of that happens. And frankly, if those trusts are written cleanly, and the person that you've appointed to manage your affairs in the trust is rather adept, they don't necessarily need to use a law firm to administer that trust at the time of your passing. They could use a law firm and sometimes decide to, but oftentimes they do those things on their own behalf. So they're avoiding that legal expense as well. So what are the parts? What is it? So a trust is just a contract. That's all that it is. You come to Nugen Law, you say, please write this document for me, you're indicating where your assets are going to go, who's going to manage that. So you are asking Nugen Law to write that trust for you, write that contract for you. And the positions inside of that trust, we have someone called a settlor, grantor, trust maker. That's you. That's the person that wrote the trust. You're the settlor. You're the grantor. You're the trust maker. You made that trust. The next position that we have with those trusts is someone called a trustee, like a manager. They're the individual that manages what's inside of that trust. And they then are responsible for doling the money out, distributing the money at the time that you pass. So generally during your lifetime, you are your own trustee. You have complete management over the assets in this revocable living trust. So in a revocable living trust, you typically are your own trustee. You're your own manager. You have complete control over everything. You don't give up one little bit of control. And then who you've appointed, should you become incompetent, incapacitated, or you pass away to become trustee, they then step in if you no longer can serve because of incompetence, incapacity, or you've passed. Then the third category in these trusts is someone called a beneficiary. So a beneficiary is the person that benefits from or enjoys the money from that trust. So if you are the trust maker and you are the trustee and you're the lifetime beneficiary, so during your lifetime you get the benefits from that trust, you enjoy everything that's in there. It doesn't go anywhere. At the time of your passing, if the money is being distributed to children, churches, charities, temples, wherever it may be that you're sending your funds, then that's where the money goes. They become the ultimate beneficiaries. So there are a multitude of types of trust. So trust is a giant umbrella, and under that are dozens and dozens of different types of trusts. But There's a type of a trust called a testamentary trust. That would be relevant to a lot of folks. So inside their will, last will and testament, they tuck something called a testamentary trust. And the testamentary trust is established at the time of your passing. And so the money is there. It would be doled out over time to your kids, to charities. So it isn't distributed all at once. So we can do that, tuck that inside of the will. We also have again the revocable trust. This is the living trust. That's generally what people are setting up when they're not worried about protecting assets as they age. They're just wanting to avoid probate, avoid the expense of that, and make sure that they're short-circuiting that length of time that probate can take. So as a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. If you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738, speak with one of our intake specialists, and schedule a meeting in either our Fort Wayne or our Auburn location. We're also having a free seminar on August 15th between 1 and 5 p.m. here in Fort Wayne, where some of these documents and much more will be discussed. So if you give us a call and reserve your spot there, 260-925-3738. Before getting on to our next instrument, let's talk about some facts that I believe motivate our clients to seek our help. So here are the facts. 5.7 million people in the United States are currently living with Alzheimer's, a type of dementia. It's diagnosed every 65 seconds. It's increasing to every 33 seconds by the year 2050. 1 in 3 seniors dies with some type of a dementia. The cost of care can be devastating. So that's typically true when you learn that 7 out of 10 people will need long-term care at some point in their lifetime. Long-term care is necessitated when someone needs help with activities of daily living like eating, bathing, dressing, using the restroom. And what are the average costs of care in Indiana? So if you want someone to come into your home, you're looking at spending around $70,000 a year. Adult daycare, around $70,000 a year. Assisted living stays, around $60,000 a year. Nursing home in Fort Wayne, the average is around $111,000 a year for a semi-private room and $137,000 a year for a private room. My experience has been that a lot of our clients are motivated to contact us when they need help. They're seeing a family member or friend has lost all of their money, providing care, payment for their care. They don't want to have the same thing happen to them or to their parents. So our job at Nugen Law is to make sure that doesn't happen to them, which we do every day. How do we do that? We can protect assets using a unique type of an irrevocable trust. So the trust I spoke about earlier, that living trust, is a one type of a trust. Now we're going to be talking about an irrevocable trust, and this type of a trust we refer to as an asset protection trust. At their core, they have the same players as a revocable trust: settlor, trust maker, manager, trustee, and beneficiary. I like to describe these trusts, they're like a treasure chest. So Nugen Law clients have us prepare the trust, that chest, that treasure chest, and they put their assets into that treasure chest, lock it, and then give the key to someone that they trust. That could be a child, could be a family member, a loved one, someone that they've known for an extended period of time. And we want the treasure to be in that treasure chest for a period of 5 years or more. They believe they'll need assistance. Now, we don't have a crystal ball. So what's the appropriate age to do these? Ideally, someone by their mid-70s has this in place, but I always give my own family as an example. My grandparents passed at 100 and 101. My great-grandfather passed at 110. My gosh, they could have done these trusts up into the age of 95 and still been good. But typically, I encourage folks to consider doing these maybe in their mid-70s. Sometimes it's earlier, depending upon health risks that the clients have or health conditions that they have dealt with in the past, which may expedite the timeline in which people are doing these trusts. I've done these trusts for people in their 50s. So it really is client-specific. So I think what's important to understand is that even though a child or loved one, a family member may be holding a key to that treasure chest, to that trust, those assets could not be accessed by their creditors, couldn't be accessed by if they had a healthcare condition, couldn't be accessed if they were getting a divorce, et cetera. That's typically a question that arises. So this analogy between this asset protection trust and the treasure chest is just that. It really is a very complicated instrument and one that needs to be very thoroughly understood before entering into it. So I've mentioned earlier the need for the 5 years. Why 5 years? Well, Medicaid is something that has a look-back period. That means that for the past 5 years, Medicaid is going to look back and see, what did you do with your money for the past 5 years? Have you given it away? Have you lost control over it and not gotten a benefit in return? That's recognized as a gift. And if you've been involved in a gifting process, then it could negatively impact your ability to get Medicaid. The penalty will be the number of weeks or months that you cannot get Medicaid benefits. And frankly, if you get into that situation, the penalty is normally more significant than had you not gifted in the first place. So the sooner these trusts are put into place, the better. People oftentimes confuse Medicare and Medicaid, thinking, I don't need that trust. Medicare will provide payment for my care as I age. Well, Medicare provides payment for things like medical expenses and when appropriate, rehabilitation at a nursing home. But it does not provide payment for personal care or for a skilled stay in a nursing home, long-term skilled stay, or memory care unit for extended periods of time. I think this confusion stems from the fact that Medicare will provide payment for rehabilitation for a period of time. So up to 20 days if you're on Advantage Medicare, or up to 100 days if you have something called traditional Medicare. So Advantage sounds like it would be more robust, but actually traditional Medicare pays more than Advantage plan. But rehabilitation should not be confused with longer-term skilled care. Rehab is intended to get you back on your feet so you can go home. What I'm talking about Nugen Law assisting with is how to obtain Medicaid should you need help after rehab, either at home or in a facility like a nursing home. Medicaid has very strict guidelines related to your assets and your income. So our job at Nugen Law is to protect your assets in such a way that you qualify for those Medicaid benefits. So if you were reticent to create a trust 5 years in advance or had an unexpected event which created the need to have in-home personal care, moving to an assisted living stay or a nursing home, it's never too late to protect some or all of your assets. We can always protect assets at Nugen Law. It's heartbreaking to me when I hear stories about mom, dad, grandma, etc., having to sell the lake house, having to sell the house in town, running through their retirement that they worked so hard and labored so hard for care when there's another source that could provide payment for their care. It never needs to happen. At Nugen Law with offices in Auburn and Fort Wayne, we utilize recognized techniques in crisis situations, as I've just described, to protect money. Normally, if one is married, 100% of the assets can be preserved. While not typically 100% of the assets can be protected if a person is single, a lion's share of their money may be able to be saved. So the amount to be protected for a single person depends in large part upon the cost of care for them, their income level, and the type of assets that they have. Rest assured, no approach to asset protection is done in a manner that has not been recognized by Medicaid as being appropriate. So what does Medicaid pay for? Why do I want that? Well, if you're a resident of Allen County, you can participate in the PACE program, PACE program. That stands for Program for All-Inclusive Care to the Elderly. It's an excellent program. You may also ask to receive benefits to provide care for you in your own home. So an assessment will be performed to determine how much care you receive in your home, 6 hours a week, 15 hours a week, 20 hours a week, whatever it may be. They won't pay for 24-hour-a-day care, but they will pay really significant care for licensed care providers to come into your home and care for you. So that may forestall or negate the need to move from your home to an assisted living facility, memory care unit, etc. Medicaid can pay for any number of things. So as a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. If you'd like to discuss more in detail about some of the instruments I've reviewed today, including those asset protection trusts or crisis planning, if you're already paying for your care, please give us a call at 260-925-3738 and reach out to one of our intake specialists, and they'll schedule a time for you to speak with one of our attorneys. I do look forward to meeting you at your appointment with Nugen Law and with speaking with you, our listeners, next weekend, Saturday at 9 a.m. If there's a topic you'd like for me to address here on our radio show, please send an email to us at help@nugenlaw.com, and we'd be happy to hear from you on topics relevant to you and your family. Enjoy your weekend.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to nugenlaw.com or email help@nugenlaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.